My name is Frank Howell, and I'm going to do a presentation today about a very important court case known as CB versus Fairlawn. A little background information about the case. Elle was a young girl from New Jersey with autism, and she's the main focus of this court case. Fairlawn was the school district in New Jersey that Elle attended, and she was placed in that school district's Stepping Stones program for students with autism at the age of 3 in 2007. She did have an IEP, however, it did not provide interaction with students without disabilities, although her IEP was approved. Stepping Stones would give her 3 hours a day of discrete trial instruction based on applied behavioral analysis, also known as ABA, which is a research-based system of educating children with autism. ABA will provide for mainstreaming of students when the child has adequate skills that enable a meaningful interaction with a more typical or oftentimes non-disabled peer. Elle would participate in activities with other children who also had autism, although not typically with non-disabled kids at this school. She was considered by the school to be one of the lower functioning kids out of the entire program. Her parents in the fall of 2007 wanted her to have an alternative placement so that she could interact more with typically developing peers. Fairlawn schools in November of 2007 denied their request, and they had another IEP meeting on December the 20th, 2007, which was held upon the request of the parents who wanted her placement changed to the Children's Center, and the Children's Center was privately funded and at Montclair State University, to show that they felt that Elle would be benefited and was capable of performing around these more typical peers. They made a videotape which they submitted to the Fairlawn School, which is a little bit of foreshadowing for this case because of some of the events that are going to come up later regarding that video. At the December 2007 IEP meeting, there had been a pre-meeting where the Fairlawn staff had met, and that's also going to be important for future reference because the parents are later going to be mad that they were not invited to that particular IEP meeting. The IEP that they came up with on December the 20th did not provide for any interaction with non-disabled children because Fairlawn just simply did not believe that Elle had the skills that would allow her to benefit from the interaction with non-disabled peers. The staff said they would continue to monitor her progress, and if she showed improvement, then maybe they would find a way to make her program a little bit more inclusive with the higher level of students at Fairlawn. So the parents decided to get her out of Stepping Stones and out of Fairlawn and try to get her into the Children's Center, despite Fairlawn having what they called a reverse inclusion component, which would occasionally take a kid that was a non-disabled kid and put them in amongst the autistic kids or other kids with disabilities to show some type of peer modeling that the kids could do to potentially improve their behavior. So Fairlawn did have something in place to try to bring things into a little bit more of an inclusive environment. Anyway, the parents did transfer her nonetheless from Stepping Stones to the Children's Center, and at the Children's Center they did have a program where she was included with non-disabled and disabled children. And then the parents decided that they should be compensated because this is a privately funded school, and they felt like they were wronged by Fairlawn because Fairlawn did not provide her with inclusive education. So they go to court, and the New Jersey Office of Administrative Law begins a little bit of a due process hearing regarding the case, and the administrative law judge, or the ALJ, had to decide if Fairlawn's placement of Elle complied with the Individuals with Disabilities Education Act. The ALJ also determined that if Fairlawn's placement did not comply with IDEA, he would then decide if the Children's Center was an appropriate placement. The ALJ said he would exclude evidence that was not relevant to the questions regarding whether or not Elle had received a fair and appropriate education in the least restrictive environment. So that's all he wanted to determine is, did Fairlawn give her a free and appropriate education, and did they provide for the LRE? The judge ultimately determined that Fairlawn had complied with the IDEA. And the video that the parents provided earlier to try to make it appear that she was capable of interacting and would benefit from non-disabled students kind of hurt them a little bit with regards to the judge, because after viewing that videotape, he kind of felt like it was more proof that validated Fairlawn's position rather than the parents. So he felt like Fairlawn probably had proven that it did meet the LRE. Obviously, the parents were not happy about that decision, so they decided to have a civil action that would be brought up in the United States District Court for the District of New Jersey. The parents wanted to admit evidence that the ALJ had excluded, but the district court sided with Fairlawn and denied additional evidence that the parents wanted to bring out in this case, because they said that they weren't really trying to show, the judge wasn't really interested in seeing her progress from the Children's Center. His only concern was, did Fairlawn meet the LRE? Did they provide her with a free and appropriate education? So the issues pertaining to the Children's Center, he just was not really thinking that that was really relevant to the case, but the parents did. The other thing that the parents brought up is that they were not involved in the pre-meeting to the IEP, and they felt like that was a snub and that they should have been a part of the pre-meeting. However, despite what the parents felt about not being included in the pre-meeting, there already kind of had been a little bit of a legal precedent for that, and it's stated that parents need not be involved in the preparatory activities that public agency personnel engage in to develop a proposal or response to a parent's proposal that will be discussed at a later meeting. So Fairlawn was probably in pretty good legal standing with regards to that pre-meeting. There is a court case that also kind of acted as a precedent for this case. There's something called the O'Berty test, and that comes from a court case known as O'Berty versus Board of Education of Clementon School District. And in this case, there's a two-part test that is developed to determine compliance with the least restrictive environment. So there are a couple questions you can ask about the LRE. One of those questions is, can education in the regular classroom be achieved satisfactorily? And the second part of the O'Berty test is, has the school mainstreamed the child to the maximum extent possible? The administrative law judge had determined that L determined inappropriate and stigmatizing behaviors, and that she would wander aimlessly, if not in a highly structured environment, and he didn't really think that the typical regular classroom was really the place for her. So again, he's kind of backing up the position that Fairlawn had taken. The ALJ also concluded that L would not have benefited from a less restrictive environment because she would not even notice her peers being there. The ALJ said that the video provided by her parents confirmed the position taken by Fairlawn, and the ALJ said that any evidence that L was better off with non-disabled peers was really kind of a figment of her mother's imagination. There might have been some stories that her mom told about how her student or her child had been a better student around non-disabled kids, but the judge just didn't really buy those things that he considered to be anecdotal in nature. The ALJ also stated that L had made significant progress while at Stepping Stones. Again, Stepping Stones, a part of the Fairlawn School District, and Fairlawn is the one that the parents are upset with. So the judge also pointed out that Fairlawn had created a reverse inclusion program at Stepping Stones to try to be more inclusive. So that kind of gave them a little bit more weight with the judge when Fairlawn came up with that reverse inclusion program. The exclusion of evidence. Regarding that case, the parents were upset that the ALJ had excluded evidence related to the Children's Center and the progress Elle had made there. However, under the New Jersey Administrative Code, a judge has the authority to exclude evidence when the risk of it taking an undue amount of time to consider substantially outweighs its probative value. The burden of proof, kind of a dispute here. There's a court case that the Supreme Court looked at that felt that the burden of proof in a challenge to the IEP is on the party seeking relief. However, New Jersey enacted legislation placing the burden of proof on the school district. Elle's parents felt like the burden of proof was on them, and it should not have been. So it's kind of a mixed bag between some court cases and the legislature in New Jersey, and the Supreme Court is still kind of up in the air about who the burden of proof is really on. So now we get to the U.S. Court of Appeals in the Third Circuit, and they concluded that the autism preschool was the child's LRE, thus ruling in Fairlawn's favor. They did not agree with the parents and did not believe that Elle had the skills necessary to participate in an inclusion placement. And they also found that the parents were not entitled to reimbursement because the child was in a private school. In Iowa, you can see the section that determines a similar type of thing about whether or not people are compensated for when their child gets placed in a private environment. My personal comments about the case is based upon what I have read regarding this case. For what I do know, I would have to conclude that the courts did reach the right decision, and that I would probably rule in favor of Fairlawn if I was to have to make a decision based upon what has been presented to me and what I have read. However, I do have great empathy for the parents who are having probably, I'm sure, a very difficult time with the concept of really kind of how low functioning their child had been, and they want their kid to be around kids in a more inclusive environment. And I understand that, and I sympathize with them. And so it's kind of a tough question to ask sometimes. When do parents resign themselves to the idea that their child is not perceived as what some people might consider to be good enough for whatever it is that someone says their kid cannot do? So I definitely have empathy for the parents in that regard, but I still think I would side with Fairlawn in their determination that they weren't going to include her in more of the mainstream type of activities. The implications of the decision for school teams. I think that Fairlawn, unlike some of the other cases that we have seen in this class and have read in this class and discussed in this class, I think that Fairlawn did a pretty darn good job of trying to make sure that they had their bases covered. I think that they probably had the best interest of the kid in mind. I don't know if the parents would probably accept that idea, but I think, in a sense, I think that Fairlawn was probably in the right place and had the right ethics and had the right ideas. But I think that they really kind of had their bases covered well, too, and those things stood up in court. Whereas if a school district might have been a little bit sloppier about documentation and communication, then perhaps they would have been not sitting as well as what they were. When a school has made the effort to be inclusive and has a plan for the possibility that maybe a kid could be involved in a more inclusive environment in the future, I think that that helps. And I think that Fairlawn did that. And if the school had made the effort to follow FAPE and LRE, they will not have to pay for the cost of another program in a private setting, and that's a pretty important point. Questions for the group. As a future administrator, how are you going to handle a situation where a parent of a child with a disability strongly disagrees with your position as to the educational placement of that child? And then the second question I would like to ask is, the courts did not think it was necessary for the parents to provide evidence of how Elle was improving her education at the Child Center. Do you think that was a mistake on the part of this court?